He handed me the easement himself, walked out to meet me on my own property, pulled the document from his clipboard folder, and put it in my hands with the confidence of someone who'd never read it closely. I read it at the creek crossing, standing on the ground my grandfather had built this ranch on in 1931. Section 7, Paragraph 3. This easement expires December 31st, 2010. I was holding a photocopy of a document that had been expired for 15 years. The pipeline it authorized had been running through my north pasture every single day of those 15 years, and the man who handed it to me, Brandon Vell, HOA president of the 180-home community whose water ran through that pipeline, was watching me read it with the expression of someone waiting for an old rancher to finish looking at something he doesn't understand. Before I handed it back, he told me not to step on the pipe. I spent 30 years as a hydrological engineer for the state of New Mexico. I designed water distribution systems. I testified as an expert witness in 14 water rights cases. I wrote easement language for more pipeline projects than I can count from memory. And I had been watching the 40-acre parcel that housed the pump station feeding that pipeline for 3 years, waiting for the right reason to move on it. Brandon Vell handed me that reason at the creek crossing. 6 months later, he had a criminal indictment on 3 counts, a civil judgment of $3,137,200, and a water supply that ran through equipment I owned, under a signed agreement for the first time in 13 years. The easement had been sitting in that clipboard folder the whole time. He just never read it. Before we dive in, comment below where you're tuning in from, and make sure to like and subscribe so you don't miss stories like this. The North Pasture fence line runs 4 miles. I check it every March, after the winter contraction has worked on the posts, and before the spring cattle movement puts pressure on the wire. It's a day's work, methodical and physical, the kind of task that clears the mind the way only repetitive outdoor labor can. You walk the line, you check each post, you note what needs repair, and you let the high desert do what it does in early spring. The light, sharp and flat, the sage beginning its first green, the Briggs Canyon ridgeline against a sky that has no equivalent anywhere else I've been. I've been walking that fence line since I was 12 years old. My grandfather built the first section of it in 1937. Cedar posts he'd cut himself from the canyon timber, set in caliche soil that fights a post hole digger the way stone fights it. My father replaced the northern run in 1968 with steel T-posts when the herd expanded and the old cedar had given what it had to give. I've replaced sections twice since I took over in 1987, once after a bad winter in 1993, and once after a flash flood took out the creek crossing posts in 2011. The fence line is, among other things, the boundary of everything my family has held for 3 generations. I noticed them at 9:40 a.m. 3 men, coming through the boundary gate at the northeast corner, the gate that accesses the pipeline corridor. They were walking the pipeline route inward, moving at the deliberate pace of people conducting an inspection, rather than the purposeful pace of people who know where they're going. One of them had a clipboard, one of them was talking. The third was taking photographs with his phone. I was 400 yards south of them when I first saw them. I finished checking the post I was working on, noted the wire tension in my log, and walked north toward the creek crossing. The creek crossing is where the pipeline transitions from buried conduit to an above-ground bridge section, a 40-foot steel span across Briggs Creek that my father had allowed the Crestfall Ridge developer to install in 2008 as part of the easement arrangement. It's the most visible section of the pipeline on my property, and it's where I knew they'd stop. They were standing at the bridge section when I reached them. The man in front turned when he heard my boots on the creek gravel. He was in his mid-50s, broad-shouldered, the kind of tan that comes from living in the desert and spending time in it intentionally rather than incidentally. He had the bearing of a man who expected to be the authority in whatever situation he entered. "Morning," he said, not a question, an acknowledgement. "Good morning." I looked at the 3 of them. The clipboard man had stopped writing. The photographer had lowered his phone. "This is private property. Did you contact my office before coming onto my land?" "I'm Brandon Vell. I'm the president of the Crestfall Ridge Community Association." He said it the way people say titles they've held long enough to consider them identity rather than role. "We're conducting a routine infrastructure inspection on the pipeline corridor. We do this annually." "Annually?" "Every spring. Standard maintenance protocol." I looked at the pipeline bridge section, then at the three men, then back at Brandon. "Did you contact my office before coming onto my land?" I asked again. A slight shift in his expression, not quite impatience, the early edge of it. "We have easement rights over this pipeline corridor. We don't need your permission to inspect our infrastructure." I looked at him for a moment. In 30 years as a hydrological engineer for the state of New Mexico, I reviewed thousands of easement documents, water rights easements, pipeline easements, access easements, drainage easements. I knew what they said and what they didn't say. I knew how they were structured, how they expired, how they transferred, how they failed. I knew, specifically, what the 2008 Crestfall Ridge pipeline easement said. I'd read it 3 years ago when I'd begun thinking seriously about the Clear Spring Aquifer Station No. 4 parcel and what it would mean to own it. I'd pulled the easement document from the Sierra County Recorder's office, read it front to back, noted the expiration clause, and put it in a file I'd been adding to since. But I wanted to see what Brandon was carrying. "Do you have a copy of that easement?" He reached into the clipboard folder and produced a document, 4 pages, photocopied, the kind of copy that comes from a copy that came from a copy, the print slightly degraded through generations of reproduction. He handed it to me with the confidence of a man who has never read the thing he's presenting. I took it. I read page 1, standard easement header, grantor, grantee, property description, purpose. Page 2, pipeline specifications, corridor width, maintenance provisions. Page 3, I found the clause in the 3rd paragraph of Section 7. This easement is granted for a term of 2 years, commencing January 1st, 2009, and expiring December 31st, 2010. Upon expiration, all rights granted hereunder shall cease, and the easement holder shall have no further right to maintain, operate, or access the pipeline or corridor without a new written agreement executed by the grantor or grantor's successors in interest. I read it twice. Then I looked at the date at the top of the document. January 14th, 2009, 16 years ago. The easement had expired December 31st, 2010, 15 years ago. The pipeline had been operating on my land for 15 years past the expiration of the only legal authorization that had ever permitted it to be there, and Brandon Vell had handed me the document proving it. I looked up at him. He was watching me with the expression of a man waiting for an old rancher to finish reading something he doesn't fully understand, so they could get back to the inspection. I said nothing. The creek moved under the pipeline bridge. A red-tailed hawk was working the thermals over the canyon ridgeline to the west. The sage smelled the way it smells in early March, when the overnight cold has just released it into the warming morning, sharp and clean and specific to this place. Brandon misread the silence. "Look," he said, with the tone of someone making a concession they consider generous. "We're just here to check the line. Annual inspection. Note the condition of the bridge section. Check the buried runs on both ends. Takes about 2 hours. We're not here to cause any issues." He paused. "Don't make this difficult." He looked at me. "Don't step on the pipe, old man." I looked at him for a moment. 71 years old. 30 years as a state hydrological engineer. The man who'd designed 3 of the major water distribution systems in southern New Mexico, who'd testified as an expert witness in 14 water rights cases, who'd written the easement language for more pipeline projects than he could count from memory. "Don't step on the pipe." I handed him back his document. "I'll be in touch," I said. I turned and walked back toward the ranch house. I didn't look back. I didn't need to. I knew what was behind me. 3 men at a pipeline bridge section on my land, holding an expired easement, with no idea what they'd just handed me, or who they'd handed it to. My grandfather had built the first structure on Briggs Canyon Ranch in 1931, a 1-room stone house at the base of the canyon, using rock he'd quarried from the canyon wall. He'd arrived in Sierra County with $800, a team of horses, and the particular stubbornness of a man who'd decided on a place and was going to make it work, regardless of what the desert thought about the matter. He'd built the stone house, drilled the first well, and started running cattle on land that most people would have looked at and called too dry, too rocky, too isolated to be worth the effort. He'd been wrong about none of it. My father had taken the ranch from 400 acres to 2,400. He'd expanded the herd, improved the well system, built the outbuildings, and negotiated the 2008 easement with Harlan Mott's Crestfall Development Company. a 2-year temporary arrangement that he'd expected to be followed by a permanent easement negotiation once the development was fully operational. That negotiation had never happened. Harlan Mott had gotten what he needed, a pipeline route across Briggs Canyon Ranch to supply water to his development, and had dissolved his company in 2012 before anyone had pressed him on the permanent easement. The HOA had taken over operation of the pipeline without, apparently, ever reviewing the easement document carefully enough to notice it had expired. My father had died in 2016. I'd inherited the ranch, and with it, the expired easement situation. I'd reviewed the documents when I settled the estate. I'd noted the expiration. I'd thought about addressing it immediately, and then, in the way that a man settling his father's estate while managing a ranch full-time finds some things sliding to a later moment, I'd filed it away. 3 years ago, I'd pulled it back out. I'd been watching the Clear Spring Aquifer Station No. 4 parcel since 2022, a 40-acre parcel containing the pumping station that fed the Crestfall Ridge pipeline, owned by Harlan Mott's dissolved development company, sitting in Sierra County's delinquent tax rolls, accruing unpaid taxes at the steady rate of $5,875 per year. I'd calculated when the back taxes would reach a figure worth acting on. In 2025, 8 years of delinquency would bring the total to $47,000. I'd been a water engineer for 30 years. I understood aquifer rights, pump station ownership, and water supply agreements in the way that most people understand the street they grew up on, completely, intuitively, and with the specific knowledge of someone who has seen every way they can be used and misused. I knew what owning that parcel would mean. I've been waiting for the right moment to move on it. Brandon Vell had just given me the reason. I walked into the ranch house, went to my office, the same room where my father had kept his papers, the same desk, the same view of the canyon, and picked up the phone. Sandra Cho had been my attorney on water rights matters for 8 years. She worked out of Albuquerque, specialized in New Mexico water law and property easements, and had the specific quality I valued most in legal counsel. She told me what the situation was, not what I wanted to hear about it. She answered on the second ring. Sandra, 3 men just walked onto my ranch without permission to inspect the Crestfall Ridge pipeline. The HOA president handed me a copy of the easement. And? It expired December 31st, 2010. A pause. He handed you an expired easement. He handed it to me and told me not to step on the pipe. Another pause. Longer. Walter. Her voice had the quality of an attorney who has just been handed something she's going to enjoy working with. Are you still looking at the Clear Spring parcel? I've been looking at it for 3 years. The back taxes. $47,000 as of this year. And you want to move on it now. I looked out the window at the canyon ridge line. The hawk was gone. The morning light was doing what New Mexico morning light does when the sun gets above the ridge, turning the high desert from shadow to a kind of burnished gold that makes the whole landscape look like it was designed rather than formed. Brandon Vell told a retired water engineer to stay off his own pipeline, I said. Yes, I want to move on it now. Sandra was quiet for exactly the right length of time. I'll pull the easement from Sierra County records today and start the tax deed process tomorrow. Good. Walter, does he know who you are? What you did for 30 years? I thought about Brandon's expression at the creek crossing, the photocopy in his hand, the tone of a man who'd assessed a 71-year-old rancher and concluded that the assessment was complete. No, I said. He doesn't. Then he has no idea what's coming. No, I said. He doesn't. Sandra called back on Thursday afternoon. 3 days of work, Sierra County property records, the original easement filing, the HOA's publicly available financial disclosures, the pipeline's operational history pulled from county infrastructure records, and a title search on the Clear Spring Aquifer Station No. 4 parcel that she'd run simultaneously because I'd told her to. I was in the ranch office when she called. The same desk, the same view of the canyon, the afternoon light doing what it does in March in the high desert, coming in low and direct through the west-facing window, turning the room amber in a way that made the old wood of the desk look like it was lit from within. Start with the easement, I said. The 2008 easement is recorded in Sierra County as document number 2008-04471. 4 pages. Grantor, Harold C. Briggs, your father. Grantee, Crestfall Development LLC, Harlan Mott, registered agent. She paused. Walter, the expiration clause is in Section 7, Paragraph 3. It's not ambiguous, it's not buried, and it's not qualified by any renewal provision. The easement expired December 31st, 2010, period. No renewal option. No renewal option, no automatic extension, no holdover provision, no language suggesting that continued use after expiration would constitute anything other than trespass. The document is clean, and its termination is absolute. She paused. I pulled the Sierra County Recording Index going back to 2009. There is no permanent easement recorded, no replacement easement, no extension agreement, no new document of any kind filed between Briggs Canyon Ranch and Crestfall Development LLC or any successor entity. And between the ranch and the HOA directly? Nothing. The Crestfall Ridge Community Association has never executed or recorded any easement, license, or access agreement with the Briggs family or the Briggs Canyon Ranch in any form. She let that sit for a moment. The pipeline has been operating on your land for 15 years and 2 months, without any legal authorization whatsoever. 15 years and 2 months. I'd known the number, roughly, since I'd first pulled the easement document 3 years ago. But hearing it stated precisely had a different quality, the specificity of a legal accounting rather than a personal one. What's the operational history? The pipeline went active in March 2009. I pulled the county utility connection records. It has been in continuous operation since then. Water pressure logs from the HOA's own annual infrastructure reports, which they file with Sierra County as a condition of their utility permit, show uninterrupted service for 16 years. She paused. 16 years of continuous operation on your land, 15 of those years without a valid easement. The fees. This is the part I want you to hear carefully. I heard paper. The Crestfall Ridge Community Association began collecting what they describe in their HOA disclosures as water infrastructure and maintenance fees in 2009, the year the pipeline went active. The fee is $600 per household per year, collected quarterly at $150. 180 households. 180 households at $600 per year. That's $108,000 per year. She paused. 16 years of collection, Walter, from 2009 through 2025. Total water infrastructure fees collected from Crestfall Ridge residents, $1,728,000. I looked at the canyon through the window. $1,728,000. Collected from 180 families, ostensibly for water infrastructure and maintenance. For use of a pipeline that crossed my land on an easement that had expired after 2 years. For 16 years of trespassing on Briggs Canyon Ranch. Not 1 cent of it had ever been offered to me. Has any portion been used for actual pipeline maintenance? I asked. I pulled the HOA's itemized expenditure reports. They're required to file those as part of their annual disclosure. Documented pipeline maintenance costs over 16 years total $127,400. Materials, labor, the bridge section inspection they apparently conduct annually. She paused. 7.4% of what they collected. The other $1,600,600 went somewhere else. I noted that number without comment. We'd return to where the money went. That was a separate question with its own answer. The adverse possession question, I said. Sandra had anticipated it. I'd have anticipated it myself in her position. It was the first defense any HOA attorney would reach for when confronted with 15 years of continuous pipeline use. New Mexico recognizes prescriptive easements through adverse possession. 10 years of open, notorious, hostile, and continuous use can establish a permanent easement right, even without the landowner's permission. The pipeline had been there for 15 years. On the surface, the math looked favorable to the HOA. Run it for me, I said. New Mexico prescriptive easement requires the use to be adverse, meaning hostile, under a claim of right, without the owner's permission. That's the critical element. She paused. Walter, I went back to the 2008 easement document, Section 8, Paragraph 2. I want to read it to you exactly. Go ahead. Grantee acknowledges that this easement is granted solely by permission of the grantor, and that grantee's use of the pipeline corridor under this agreement is permissive in nature. Grantee further acknowledges the exclusive ownership of the pipeline corridor by grantor, and agrees that use under this easement shall not be construed as adverse, hostile, or under a claim of right for any purpose, including, but not limited to, the establishment of any prescriptive easement or other permanent right of access. She let the paragraph sit in the air between us for a moment. Your father's attorney put that language in the 2008 document, she said. He did. My father had used the same property attorney for 30 years, a man named Carl Reeves in Truth or Consequences, who'd been drafting New Mexico ranch easements since the 1970s, and understood, with the bone-deep certainty of someone who'd seen what happened when the language was loose, exactly how to close the doors that needed closing. Carl Reeves drafted it. He told my father specifically, if this is temporary, we make sure they say it's temporary in their own words. He was right to do it. The acknowledgement language in Section 8 defeats the adverse possession claim completely. You cannot establish a prescriptive easement on use that was explicitly licensed and explicitly acknowledged as permissive. The clock for hostile use never started because the use was never hostile. It was permitted, acknowledged as permitted, and the grantee signed a document saying so. They signed away their own prescriptive easement claim in 2008. They signed away their own prescriptive easement claim in 2008, Sandra confirmed, in a document that Harlan Mott executed on behalf of Crestfall Development LLC, and that the HOA inherited when they took over the pipeline operation. She paused. Their own document defeats their best defense. Whatever attorney the HOA hires is going to read Section 8 and have a very difficult conversation with Brandon Vell. I leaned back in my father's chair. The desk had been his since 1971, a big oak partner's desk that he'd bought from an estate sale in Elephant Butte and driven home in the back of his truck. I'd sat across from it as a boy while he reviewed ranch accounts, sat behind it since 2016, and had never once thought of replacing it. The water source, I said. Clear Spring Aquifer Station Number 4. Her voice changed, the specific quality of an attorney who has arrived at the part of the briefing she's been looking forward to. The pumping station sits on a 40-acre parcel, approximately 3.2 miles north of your ranch boundary. The parcel was purchased by Crestfall Development LLC in 2007 as part of the Water Infrastructure Assembly for the Crestfall Ridge Project. When Harlan Mott dissolved Crestfall Development LLC in 2012, the parcel was not transferred to any successor entity. It stayed in the name of the dissolved company, which means no one was paying the taxes. Sierra County began issuing delinquency notices in 2017, 5 years after the company dissolved with no registered agent to receive them. The notices went unanswered. The parcel has been accumulating delinquent property taxes since 2017. She paused. 8 years of unpaid taxes at the current Sierra County rate for unimproved commercial parcels with utility infrastructure. $5,875 per year. $47,000. $47,000 in back taxes, yes, which is the current threshold for Sierra County's delinquent tax deed process. She was quiet for a moment. Walter, you can buy the water source. I looked at the canyon. The late afternoon light had shifted while we'd been talking, the amber deepening toward the specific gold of a New Mexico desert evening, the shadow line from the canyon rim moving slowly across the pasture. The north pasture, where I'd been checking fence line on Tuesday morning, where 3 men had walked through my gate without asking. I know, I said. I've been looking at that parcel for 3 years. Sandra was quiet. You've been waiting, she said. I was waiting for the right reason. She processed that for a moment. The March incident. Brandon Vell walked onto my land without permission, told me I needed his approval to access my own property, and handed me a copy of an easement that expired 15 years ago. I paused. That's the right reason. Walter, if you acquire the Clear Spring parcel through the tax deed process, you understand what that does to the HOA's water supply situation. I designed water distribution systems for 30 years, Sandra. I understand exactly what it does. The existing pump operation agreement, the one Harlan Mott established between Crestfall Development LLC and the County Water Authority, transfers with the property. But the agreement between Crestfall Development LLC and the HOA for the water supply itself was with a company that dissolved in 2012. It's been running on nothing for 13 years. No valid counterparty, no current agreement. I paused. When I own that parcel, I'm the water source. The HOA needs an agreement with me, and you control whether they get one. I control whether they get one. Sandra was quiet for a moment, the kind of quiet that a good attorney goes into when they're running the legal sequence forward to make sure the architecture holds. The tax deed process takes approximately 90 days from application to issuance, assuming no redemption challenge. The HOA would receive standard notification as an interested party. Their pipeline connects to the parcel. Will they move to redeem? They're not the property owner. They have no standing to redeem. Redemption rights belong to the delinquent taxpayer or their successors. Crestfall Development LLC dissolved with no successors. There's no one with standing to redeem. She paused. The notification goes out. They see it. They have no legal mechanism to stop it. Then start the process. I'll file the tax deed application with Sierra County on Monday. She paused. And the easement matter. How do you want to handle that in parallel? Formal trespass notice once the tax deed is in hand. I want both pieces in place before I move formally. The easement enforcement and the water source ownership together. That's a stronger position. That's the point. I looked at the pipeline bridge section visible through the office window, the steel span over Briggs Creek, catching the last of the evening light. Brandon Vell has been treating my ranch as his infrastructure corridor for 6 years as HOA president. His predecessors did the same for 9 years before that. Nobody ever called my office. Nobody ever asked. They just assumed that because the pipeline had been there for a long time, it belonged there. And it doesn't. It hasn't belonged there since December 31st, 2010. I paused. I want Brandon Vell to understand the full landscape before he decides whether to negotiate or fight. I want him looking at an expired easement on one side and a water source he no longer controls on the other. And then I offer him exactly what my father would have offered Harlan Mott in 2010 if Mott had bothered to call. A fair permanent easement, a fair water supply agreement, properly recorded, properly priced, properly documented. I paused. I'm not trying to destroy the community. I'm trying to establish what should have been established 15 years ago. And if he refuses? I looked at the canyon rim. The shadow line had reached the creek. In 20 minutes it would be dark. Then he finds out what it means when a retired water engineer owns the ground the pipeline crosses and the pump station that feeds it. Sandra filed the tax deed application on Monday morning. The Sierra County Assessor's Office acknowledged receipt on Wednesday. The standard 90-day process had begun. I went back to checking the North Pasture fence line. The Sierra County tax deed process is not complicated. It is, by design, methodical. A sequence of notices, waiting periods, and administrative steps that exist to ensure that a property owner with the ability to pay their taxes has every reasonable opportunity to do so before the county transfers the deed to someone else. The process is fair. It is also, once it begins, essentially unstoppable if no one with legal standing to stop it chooses to act. The notification went out in late March. Sierra County mails standard delinquent tax notifications to all parties with a recorded interest in or connection to a tax delinquent parcel, the delinquent owner, any recorded lien holders, and any parties whose recorded documents reference the parcel. The Crestfall Ridge Community Association's utility permit, filed with Sierra County, and referencing the Clear Spring Aquifer Station No. 4 parcel as the water source for the development's pipeline, qualified them for notification as an interested party. Their letter arrived at the HOA's registered address on March 28th. I know what happened next because Margaret Okafor, who in this context I'll call by the name Sandra, used when she described her source inside the Crestfall Ridge community. A resident named Carol Fitch, who attended board meetings and had begun, after the March pipeline incident, keeping detailed notes, told us later. Brandon had opened the notification at his kitchen table. He'd read the first paragraph, standard Sierra County delinquent tax language about a parcel at the Clear Spring Aquifer Station address, and called the HOA's attorney immediately. The attorney, a general practice lawyer in Truth or Consequences named Douglas Webb, who handled the HOA's routine legal matters, had reviewed the notification and given Brandon the assessment that, from a narrow legal standpoint, was accurate. It was a routine tax matter. The HOA was not the property owner. The HOA had no standing to redeem delinquent taxes on a parcel they didn't own. Redemption rights belonged to Crestfall Development LLC or its successors, and Crestfall Development LLC had dissolved in 2012 with no registered successors. Douglas Webb had told Brandon there was nothing to do. Brandon had not pursued it. The redemption window closed on April 30th. No redemption was filed. The Sierra County tax assessor issued the tax deed on May 14th, 2025. Grantee, Walter H. Briggs. Property, 40 acres, Clear Spring Aquifer Station Number 4, Sierra County, New Mexico, including all improvements, water infrastructure, pumping equipment, and appurtenant water rights as described in the original 2007 warranty deed. The deed was recorded in Sierra County at 9:02 a.m. on May 14th. I was at the ranch when Sandra called, standing at the kitchen window with coffee, the same view I'd had since childhood, the canyon wall, the morning shadow still on the near pasture, the pipeline bridge section just visible at the creek crossing. "It's recorded," she said. "You own it." "Good. Walter, I want to make sure you understand the full picture of what you now hold. The Clear Spring Aquifer Station Number 4 parcel includes the pump house structure, the primary pump equipment, the electrical infrastructure, and, this is the important part, the water rights certificate. The certificate covers the aquifer draw rights associated with the station. Under New Mexico water law, those rights are appurtenant to the land. They transferred with the deed." "I know. The HOA's pipeline connects to that pump station. Their entire water supply for 180 homes runs through equipment that now sits on your land and operates under water rights that are now yours." "I know. I want it stated clearly so there's no ambiguity when we file the notices. State it however you need to." The formal notices went out on May 19th, 5 days after the deed recorded. Sandra had prepared both documents in advance, finalizing them the moment the recording confirmation came through. The first notice was the easement trespass demand. Addressed to the Crestfall Ridge Community Association, Brandon Vell as president, and Douglas Webb as HOA counsel. 4 pages. It opened with the recorded deed citation for Briggs Canyon Ranch, the full ownership documentation, the chain going back to Walter's grandfather's original 1931 filing. It cited document number 2008-04471, the temporary construction easement, and quoted Section 7, Paragraph 3 in full. It stated the expiration date, December 31st, 2010. It noted the absence of any subsequent easement, extension, or access agreement in the Sierra County records. The operative paragraph was the third one. The Crestfall Ridge pipeline has been operating on Briggs Canyon Ranch without legal authorization since January 1st, 2011. This constitutes continuous trespass on private property under New Mexico law. Mr. Briggs demands the following: immediate acknowledgement of the expired easement status, immediate commencement of good faith negotiations for a permanent recorded easement at current Sierra County fair market rate for pipeline corridor access, and full accounting of all water infrastructure fees collected from 2011 through present, which fees were collected in part for the purported maintenance of infrastructure operating on Mr. Briggs's land without authorization. Restitution demand for 15 years of unlicensed use, $162,000, calculated at the fair market annual rate for pipeline easement access in Sierra County, $10,800 per year for 15 years. The second notice was the water source notification. This one was addressed to the same parties but cited a different document, the May 14th tax deed recording for the Clear Spring Aquifer Station Number 4 parcel. It stated one thing, in plain language, before the legal provisions. Walter H. Briggs is the owner of record of the Clear Spring Aquifer Station Number 4 parcel, including the pump house, pump equipment, electrical infrastructure, and all associated water rights, effective May 14, 2025. The existing water supply arrangement between Crestfall Development LLC and the Crestfall Ridge Community Association is void. Crestfall Development LLC dissolved in 2012. No valid counterparty to that arrangement exists. The arrangement has been operating without a valid principal for 13 years. A new water supply agreement must be negotiated with Walter H. Briggs, current owner of the Clear Spring Aquifer Station No. 4 parcel, before continued operation of the pump station can be authorized. Mr. Briggs is willing to negotiate fair, long-term water supply terms. He requests that the HOA contact Sandra Cho's office within 30 days to initiate that negotiation. Both notices were delivered by certified mail on May 19th. Both were received and signed for on May 21st. Brandon called an emergency board meeting that evening. Carol Fitch attended. She described it to Sandra the following day. Brandon had opened the meeting by reading both notices aloud to the 5-member board. His voice, by Carol's account, had the controlled quality of a man working hard to project authority over a situation he was not fully in control of. His initial position: he can't own our water. The water comes from the aquifer. You can't own an aquifer. Douglas Webb, sitting at the end of the table, had corrected him carefully. Brandon, what he owns is the parcel containing the pump station and the water rights certificate. Under New Mexico law, water rights are property. They're held by certificate, and they transfer with the land they're appurtenant to. He bought the parcel in a valid tax deed sale. He owns the water rights. The tax deed process, can we challenge it? The redemption window closed April 30th. The deed issued May 14th. It's recorded. A challenge at this point would require demonstrating a fundamental defect in the county's process, which there isn't one. Douglas paused. Brandon, the process was legally correct. He bought the parcel. A board member named Rita Solis. What about the easement, the trespass claim? The easement issue is separate, but it's real. I reviewed the 2008 document when you asked me to look at the March situation. Section 7 is clear, 2-year term, expired 2010, and Section 8 has acknowledgement language that's going to make prescriptive easement arguments very difficult. Brandon, then we'll fight the easement and keep the water running. Douglas, Brandon, those are two separate matters. You can contest the easement trespass claim. That's litigation we can pursue. But the water source is a different question. The pump station is on his land. The water rights are his. Keeping the water running requires his cooperation, regardless of how the easement dispute resolves. Silence in the room. Rita Solis. So we need to negotiate with him on the water, no matter what? Unless you want to find an alternative water source for 180 homes in the high desert, yes. Brandon's jaw tightened. Call his attorney. Tell them we're contesting the easement claim. We're not paying 15 years of back fees for a pipeline corridor that's been serving this community for 16 years. And the water negotiation? Tell them we'll talk about water when the easement issue is resolved. Sandra called me with the board meeting summary on May 22nd. Brandon's position: fight the easement, delay the water negotiation, link the two issues. That's a tactical error, I said. I know, he's treating them as leverage points against each other. But the water situation doesn't wait for the easement litigation to resolve. The pump station is on your land. His water agreement is with a dissolved company. Those facts don't change based on what happens in the easement dispute. Did Douglas Webb tell him that? Douglas Webb told him exactly that. Brandon's response was to fight the easement and keep the water running. I looked out at the pasture. The afternoon was warm for May. The desert warming early. The creek running steady from the spring snowmelt still coming down from the mountains. The easement and the water are two separate negotiations, I said. He can fight one and still need the other. That's fine. How long are you willing to wait? I thought about the 40-acre parcel I now owned 3 miles north of my boundary. The pump house, the equipment, the water rights certificate with my name on it. I thought about Brandon Vell at the creek crossing in March, the photocopy in his hand. The tone of his voice. I'm patient, I said, but I'm not indefinitely patient. He has 30 days to initiate the water negotiation. After that, the pump station is mine to operate as I see fit. Sandra was quiet for a moment. Walter, when you say operate as you see fit, I mean that a pump station on private land requires the landowner's authorization to operate. If there's no agreement in place, the authorization isn't there. Another pause. The board won't understand that until it happens. No, I said. They won't. Sandra pulled the financial records in the first week of June. New Mexico's Homeowner Association Act requires HOAs to maintain financial records and make them available upon written request to any member with a legitimate interest. As the ground lessor of the pipeline corridor and the owner of the water source parcel, both directly implicated in the HOA's water infrastructure arrangements, I had standing that went beyond membership. Sandra filed the records request on June 2nd, citing both capacities. The HOA's registered agent complied within 5 days. The records arrived as a thumb drive containing 6 years of budget documents, bank statements, vendor invoices, board meeting minutes, and annual financial disclosures filed with Sierra County. Sandra's paralegal began the review on June 9th. Sandra joined her the following morning. She called me on June 12th. "Walter, are you at the ranch?" "Always." "I need you to listen to this carefully because the numbers are significant, and I want to make sure you have the full picture before we decide how to proceed." "Go ahead." "The water infrastructure fee, $600 per household per year, 180 households, collected since 2009. She paused. "I've now confirmed the full 16-year collection history from the bank records. Total collected, $1,728,000. That figure is accurate." "You said the actual maintenance costs were $127,000. Documented pipeline maintenance over 16 years, $127,400. I verified every maintenance invoice in the records, materials, labor, the annual bridge section inspections, 2 repair events in 2013 and 2019. All of it adds up to $127,400. She paused. 7.4% of what was collected. Where did the other $1,600,000 go? That's what I've been working through for 3 days. I heard papers. Some of it is in the HOA's general operating account. About $340,000 that appears to have been absorbed into general overhead over the years, commingled with dues revenue in ways that aren't properly documented but are traceable. Some of it is in board administrative fees. $180,000 over 16 years in payments to board members for what the minutes describe as community infrastructure oversight. Not large individually, but consistent. And the rest? Sandra paused. In 20 years of working with her on water rights and property matters, I'd learned to read her pauses. This one had the quality of an attorney who has found something she needs to deliver precisely. The remaining $847,000 went to a single vendor, a company called VEL Property Services LLC. The payments appear in the HOA's expenditure records going back to 2011, the year after the temporary easement expired, coincidentally, continuing through the most recent records I have, which run to early 2025. 14 years of payments, 14 years, ranging from $48,000 in the early years to $74,000 in the most recent full year. Consistently the largest single line item in the HOA's annual expenditure report, categorized as water infrastructure management and community liaison services. I looked out the window at the pipeline bridge section. VEL Property Services LLC, I said, registered with the New Mexico Secretary of State on March 15, 2011. Single-member limited liability company. She paused. The sole member is Brandon Allen Vell. The ranch office was very quiet. He's been paying himself. He's been paying his own company $847,000 from HOA water infrastructure fees over 14 years for services rendered to an HOA he was simultaneously running as president. Her voice had the flat precision of an attorney reading a legal finding rather than editorializing on it. No competitive bidding process in any year. No board resolution specifically authorizing the VEL Property Services contract in any meeting minutes I can find. No disclosure to residents that the HOA president was the sole owner of the primary infrastructure vendor. I thought about the $1,728,000 collected from 180 families, $600 per year. Quarterly installments of $150, small enough that most households paid it without examining it closely. Collected under the label of water infrastructure and maintenance for 16 years. Of that $1,728,000, $127,400 had gone to actual pipeline maintenance. $847,000 had gone to Brandon Vell's own company. The remaining $753,600 had been absorbed into the HOA's operating accounts and administrative fees. The 180 households of Crestfall Ridge had been paying a water infrastructure fee for 16 years, believing it covered the cost of their water supply infrastructure. What it had actually covered, in substantial part, was a 14-year payment stream to the HOA president's private company for services described so vaguely, water infrastructure management and community liaison services, that they could mean almost anything or nothing at all. Did the board know? I asked. Based on the meeting minutes, no. The Vell Property Services payments appear in the annual budget as a line item, never itemized below the description I mentioned, never discussed in any meeting minutes I've reviewed. 3 of the 5 current board members have been on the board for 4 years or less. The 2 longest-serving members, Brandon and a man named Gary Hulse, who's been on the board since 2013, are the only ones whose tenure overlaps with the full payment history. Gary Hulse signed off on the budgets. Every year, as treasurer. She paused. Whether he understood what he was signing is a question the AG's investigation will determine. File with the AG. I said it without hesitation. The same decision I'd made, instinctively, when I understood the full scope of what I was looking at. This wasn't a civil matter, not exclusively. A man who collects money from 180 families under false pretenses and routes it to his own company through the authority of a position those families trusted him with is not making an accounting error. He's stealing. New Mexico AG Consumer Protection Division, Sandra said. I've been drafting the referral since yesterday morning. I wanted to brief you first. File it today. There's one more thing I want to tell you before you decide on timing. She paused. I ran a deeper search on Vell Property Services LLC. Beyond the Secretary of State registration, Brandon has been active as a commercial broker in Sierra County and the surrounding region since 2009, the same year he became HOA president. I found 3 commercial transactions in the past 6 years where Brandon represented the buyer and also received payments from the seller's side without, as far as I can determine from the public records, disclosing the dual compensation. Real estate license issues. Potentially significant ones. I've flagged it for the New Mexico Real Estate Commission referral, which I'll file simultaneously with the AG complaint. I stood from the desk and went to the window. The afternoon had turned golden, the way late June afternoons turn golden in the high desert. Everything warm and specific and unhurried. The pipeline bridge section caught the light. The creek moved below it. Sandra, the board members who didn't know about the Vell Property Services arrangement, have any of them been in contact? 3 of them called my office in the past week, independently, on different days. Carol Fitch reached out to one of them after the May board meeting, apparently, told him what she'd been observing, and suggested he might want to speak with counsel. What did they say? All 3 said the same thing in different words. They had no knowledge of the Vell Property Services contract, no knowledge that the vendor was Brandon's company, and no knowledge that $847,000 in HOA funds had gone to the HOA president's private business over 14 years. They want to cooperate with any investigation. She paused. Walter, they're also angry. These are people who've been voting on budgets for years, without knowing what the largest line item actually was. They should be angry. They want to know what they should do. Tell them to retain their own attorneys, independent counsel, not the HOA's general counsel. And tell them that the fastest path to separating themselves from Brandon's liability is full cooperation with the AG from the beginning. I'll tell them. I looked at the pipeline. 14 years. Brandon Vell had walked onto my ranch in March 2025 with the bearing of a man who owned what he was standing on. He'd told me not to step on the pipe. He'd been HOA president for 6 years at that point, but he'd been collecting payments from Vell Property Services LLC for 14 years, since 2011, since the year after the easement expired. The timing sat in my mind with a specific weight. The easement had expired December 31st, 2010. Vell Property Services LLC had been registered March 15th, 2011. 2.5 months after the easement expired, Brandon had incorporated the company that would spend the next 14 years collecting HOA money from for managing the infrastructure on my land. Infrastructure that was, from January 1st, 2011 onward, trespassing on my property. He had been collecting management fees for overseeing a trespass. Sandra. Yes. Add that to the AG referral. The timeline. Vel Property Services Incorporated 2.5 months after the easement expired. 14 years of payments for managing infrastructure that had no legal right to be where it was. I paused. I want the AG to have the full picture of what he was managing and what he knew about its legal status. You think he knew the easement had expired? He's been HOA president for 6 years, but he incorporated his management company in 2011, the year after expiration. Whether he personally reviewed the easement document, or someone told him, or he simply noticed that no renewal was ever signed, he started collecting management fees at exactly the moment the legal authorization for the thing he was managing ceased to exist. Sandra was quiet for a moment. That's a significant element. It's the element that turns negligence into something else. She filed the AG complaint that afternoon. 41 pages, the full financial record, the Vel Property Services payment history, the timeline from easement expiration to company incorporation, the 16 years of water infrastructure fees against $127,000 in documented maintenance, the board meeting minutes showing no authorization and no disclosure, the 3 cooperating board members' preliminary statements. The New Mexico Real Estate Commission referral went out the same day. The AG's office acknowledged receipt on June 16th. An investigator made contact with Sandra on June 23rd. The board meeting that week, called by the 3 cooperating members without Brandon's knowledge, using their majority to set the agenda, lasted 3 hours. Carol Fitch attended and took notes. By the end of it, the 3 cooperating members had voted to retain independent legal counsel for the HOA board, separate from Douglas Webb, and had voted to suspend Brandon's authority to execute contracts or financial transactions on behalf of the association, pending the AG investigation. Brandon had not been at the meeting. He'd been in Albuquerque, meeting with a criminal defense attorney. The indictment came down on August 7th. The New Mexico Attorney General's office had moved efficiently, the same pattern Sandra had seen with well-documented referrals in her 20 years of practice. When the financial records are organized, the timeline is clear, and 3 board members are cooperating from the beginning. The path from referral to grand jury is shorter than defendants typically expect. Brandon Allen Vel, 3 counts. Count 1. Fraud under New Mexico Statute Section 30-16-6. Collecting money from 180 households under false pretenses, specifically representing water infrastructure fees as covering the costs of water supply and pipeline maintenance while routing the majority of those fees to his own private company through a vendor arrangement never disclosed to fee payers. Count 2. Self-dealing and breach of fiduciary duty under New Mexico's Nonprofit Corporation Act, which governs HOA boards. Brandon had occupied a fiduciary position as HOA president. He had used that position to create and maintain a vendor relationship that financially benefited himself, $847,000 over 14 years, without disclosure, without competitive bidding, and without the informed consent of the board members or residents whose interests he was legally obligated to serve. Count 3. Fraudulent concealment. The systematic absence of Vel Property Services LLC from board meeting disclosures, from competitive bidding processes, and from any community communication over 14 years constituted active concealment of a material conflict of interest. Gary Hulse, the board treasurer who had signed off on 14 years of budgets containing the Vel Property Services payments, was named as a secondary subject. His cooperation with the AG's investigation had been partial and conditional. The AG's office was still determining the extent of his knowing participation versus willful blindness. Sandra called me the morning the indictment was filed. 3 counts. The AG went with fraud, self-dealing, and fraudulent concealment. Gary Hulse is still under review. They haven't decided whether to indict him separately. And Brandon's response? His criminal defense attorney issued a statement saying the charges mischaracterize what were legitimate HOA management services provided at fair market value. She paused. I've reviewed the statement. It doesn't address the absence of competitive bidding, the absence of disclosure, or the absence of any board authorization. It just asserts fair market value. What does fair market value mean for services that were never defined? Exactly the question a jury is going to ask. The civil suit had been filed in Sierra County District Court on July 15th, 3 weeks before the indictment, time to establish the civil record independently before the criminal proceedings accelerated. 4 counts. Count 1, 15 years of pipeline trespass. The easement had expired December 31st, 2010. The pipeline had operated on Briggs Canyon Ranch from January 1st, 2011 through the present day. At the time of filing, approximately 14.5 years, without legal authorization. Damages calculated at the fair market annual rate for pipeline easement access in Sierra County, $23,500 per year. Total, $340,750, rounded to $340,000. Count 2, unlicensed use restitution. The HOA had collected water infrastructure fees in part by representing to residents that the fees covered the cost of water supply and pipeline access. The pipeline access had no cost to the HOA because they weren't paying anyone for it. The fair value of the unlicensed use, what should have been paid to Walter under a proper permanent easement, was $10,800 per year for 15 years, $162,000. Count 3, misappropriation damages. The $847,000 paid to Vell Property Services, LLC, collected from 180 households through water infrastructure fees, represented misappropriated community funds. The civil claim sought full restitution plus damages. Count 4, punitive damages. The pattern of conduct, incorporating a shell company 2 months after the easement expired, collecting management fees for 14 years for overseeing trespassing infrastructure, maintaining the arrangement without disclosure through 6 years as HOA president, established the willful, deliberate, sustained misconduct that Georgia and New Mexico courts both recognize as the standard for punitive damages. Punitive damages requested, $1,694,000, equal to the misappropriation damages, reflecting the sustained duration of the scheme. Total civil demand, $3,043,000. Brandon's defense attorney filed a motion to dismiss in early September. The primary argument, prescriptive easement. 15 years of open, continuous, and uninterrupted pipeline operation on Briggs Canyon Ranch had established a permanent prescriptive easement by operation of New Mexico law, regardless of the expired written instrument. The hearing was September 22nd in Sierra County District Court. Judge Maria Sandoval presiding. 20 years on the bench, a property law background from her years in private practice in Albuquerque. Brandon's attorney presented the prescriptive easement argument for 18 minutes. He had genuine case law to work with. New Mexico courts had recognized prescriptive easements in pipeline contexts before, and 15 years of continuous use was well past the 10-year statutory threshold. The argument was structured, cited correctly, and represented the most viable theory his client had. Judge Sandoval reviewed the case file. She looked at the 2008 easement document. "Counsel," she said, "the 2008 easement agreement is in evidence. Section 8, paragraph 2. I'm going to read it into the record." She read the acknowledgement language, the entire paragraph, the explicit statement that use under the easement was permissive, not adverse, the explicit waiver of any prescriptive easement claim. She set the document down. Mr. Vell's HOA signed this document in 2008. It acknowledges the landowner's exclusive ownership of the corridor. It explicitly states that use under the easement creates no permanent right and shall not be construed as adverse or hostile for any purpose. She looked at the defense table. You cannot claim prescriptive easement on use that was expressly permitted. The hostile use element, which New Mexico law requires, is defeated by this acknowledgement. The HOA acknowledged, in writing, that their use was licensed and not hostile. That acknowledgement binds their successors in interest. Brandon's attorney. Your Honor, the easement expired in 2010. Use after expiration is no longer licensed use. Counsel. The acknowledgement in Section 8 doesn't expire with the easement term. The HOA acknowledged the landowner's ownership. That acknowledgement doesn't convert to hostile use, simply because the permission period ended. If anything, use after expiration, with knowledge of the expiration, and I note that Vell Property Services, LLC, was incorporated 2 months after expiration, suggesting, at minimum, awareness of the timing is more consistent with knowing trespass than with the hostile claim of right that prescriptive easement requires. She closed the file. The motion to dismiss is denied. We'll proceed to trial. Sandra called me from the courthouse parking lot. Dismissed. Judge Sandoval read the Section 8 language into the record herself. She also noted the Vell Property Services Incorporation timing. She saw it. She saw exactly what it was. By October, the civil suit was proceeding toward a trial date, and the criminal case was in pretrial motions. Brandon's authority over the HOA had been suspended since June. The 3 cooperating board members were running the association under guidance from their independent counsel, and the 30-day window I'd given the HOA to initiate water supply negotiations had expired in June. Then July, then August, then September. Brandon had refused to engage. His criminal defense attorney had advised him not to negotiate anything that could be construed as acknowledging my ownership of the water source parcel. The cooperating board members had wanted to negotiate. Their independent counsel had advised them strongly to reach an interim agreement with me. But Brandon had retained enough informal influence over the remaining board dynamics to block formal action. October arrived. I'd been patient for 5 months since the formal notice. Patient through the tax deed process, through the easement trespass filing, through the indictment, through the motion to dismiss. I'd offered a fair negotiation. I'd stated my terms clearly. I'd given more time than the notices required. On the morning of October 7th, I drove to the Clear Spring Aquifer Station No. 4 parcel, my parcel. The pump house was a concrete block structure, approximately 30 feet by 20 feet, well maintained by the standards of unmaintained infrastructure. The equipment inside was functional, regularly serviced by the HOA's maintenance contractor, the electrical system's current. A steel access door, padlocked, with a Sierra County utility permit placard on the exterior. I had a key. It had come with the tax deed parcel. The physical key to the pump house had been in the county's possession since Crestfall Development LLC dissolved without transferring the property, and the Sierra County tax assessor had included it with the deed documentation. I unlocked the door. Inside, 2 primary pumps, a pressure management system, the electrical panel, and the main shutoff valve, a 12-inch gate valve on the primary output line, the one that fed the Crestfall Ridge pipeline. I looked at the valve for a moment, then I turned it. Quarter turn, half turn, 3/4, full closed. The pump continued running for approximately 90 seconds, clearing the immediate line pressure. Then, the pressure gauge on the output side dropped to 0. The pipeline carrying water to 180 homes in Crestfall Ridge was no longer receiving flow from the Clear Spring Aquifer Station. I locked the pump house, drove back to the ranch, and called Sandra. "It's done. I'll file the formal notification now." The notification went to the HOA's independent counsel, not Douglas Webb, not Brandon's attorney, but the independent firm the cooperating board members had retained in June. It stated that the pump station operation had been suspended, pending execution of a valid water supply agreement with the current parcel owner. It offered to negotiate emergency interim terms immediately. The calls started within 4 hours. Crestfall Ridge residents had noticed dropping water pressure by mid-morning. By noon, the pressure was gone entirely in the northern sections of the development. By early afternoon, it was gone throughout. Brandon called me at 3:47 p.m. I answered. "Walter." His voice had the specific quality of a man who has been in controlled fury for several hours, and has now dialed back to something that sounds like negotiation, but is still fury underneath. "You can't do this. People live here, 180 families. This is their water supply." "The pump station is on my property," I said. "I own the water rights." The existing pump operation agreement was with Crestfall Development LLC, which dissolved in 2012. There is no valid water supply agreement currently in place. I sent formal notice of this in May. I offered to negotiate in May. The 30-day window I provided expired in June. "You're doing this to win a lawsuit." "I'm doing this because I own the property the pump station sits on, and there is no legal authorization for me to allow its continued operation in the absence of an agreement." "Brandon, you've had 5 months. The criminal case, my attorney told me not to." Your criminal case is about what you did with HOA money. The water supply agreement is about what you and your community need from the owner of the water source. Those are separate matters. They have been separate matters since May. Your attorney's advice about the criminal case doesn't require you to refuse water supply negotiations. I'm not going to let you use the water as a weapon. I sent notice in May. I offered fair terms. I waited 5 months. The water is off because there's no agreement, not because I'm using it as a weapon. I kept my voice level. Brandon, I'd suggest you talk to the 3 board members who have been trying to reach an interim agreement with me since June. I'd suggest you do it today. I ended the call. The 3 cooperating board members, Rita Salas, James Cordera, and Patricia Wynn, called Sandra's office at 5:30 p.m. They wanted to negotiate. They'd wanted to negotiate since June. They had their independent counsel on the call with them. Sandra and I had prepared the emergency interim agreement in advance. It was 4 pages. Simple. Walter Briggs, as owner of the Clear Spring Aquifer Station No. 4 parcel, authorized resumption of pump station operation on an interim basis pending negotiation of a permanent water supply agreement. The HOA acknowledged Walter's ownership of the parcel and the water rights. The HOA acknowledged the absence of any currently valid water supply agreement. The HOA committed to good faith permanent agreement negotiations within 90 days. No dollar amounts in the interim agreement. No admission of liability. No resolution of the easement dispute or the civil suit. Just the minimum acknowledgement necessary to get the water flowing, while the parties work toward a permanent solution. Rita Solis, James Cordera, and Patricia Wynn signed at 8:14 p.m. on October 7th. They signed as the current operating majority of the Crestfall Ridge Community Association Board, their independent counsel having confirmed that their authority to execute emergency operational agreements was valid under the HOA's bylaws. Brandon Vell did not sign. He didn't need to. 3 of 5 board members constituted the majority. His signature was not required. I drove back to the Clear Spring parcel at 9 p.m., unlocked the pump house, turned the gate valve, quarter turn, half, 3/4, full open. The pressure gauge climbed. At 9:23 p.m., 72 hours and 23 minutes after I'd closed the valve, the Crestfall Ridge water supply was restored. I drove home through the high desert dark. The sky above the canyon was what it always is on a clear October night in New Mexico. So many stars that the darkness between them seems incidental rather than dominant. The ranch road running straight toward the canyon, the pump house behind me, on my land, operating under a signed agreement for the first time in 13 years. Walter's voice, answering a question that hadn't been asked yet. The shutoff wasn't a weapon. It was a question. The same question the gate had been in the Coles Mill Road story. The same question every piece of enforcement in every situation like this ultimately is. Do you respect what the deed says? Brandon Vell had answered for 5 months by not answering. 3 board members had answered in 4 hours. That told me everything I needed to know about how the permanent agreement would go. Brandon Vell was convicted on February 11th, 2026. The criminal trial had taken 7 days. The prosecution's case was the documentation, the same documentation Sandra and I had assembled beginning in March 2025, now presented to a jury of 12 Sierra County residents, who had spent 7 days watching a prosecutor walk methodically through a timeline that required no interpretation. March 2011. Vell Property Services LLC Incorporated. Sole owner, Brandon Vell. 2.5 months after the Crestfall Ridge pipeline easement expired. 2011 through 2025. $847,000 in payments from HOA, water infrastructure fees, to Vell Property Services LLC. No competitive bidding, no board authorization, no disclosure. March 2025. Brandon Vell walks onto Briggs Canyon Ranch without permission to inspect the pipeline, hands the property owner a copy of an easement that had expired 15 years earlier. May 2025. Walter Briggs acquires the Clear Spring Aquifer Station No. 4 parcel through valid tax deed process. Brandon refuses to negotiate a water supply agreement. October 2025. Walter shuts off the pump for 72 hours. The jury had deliberated for 9 hours. All 3 counts. Guilty. Gary Hulse, the board treasurer who'd signed 14 years of budgets, had pleaded to a reduced charge of negligent financial oversight in December, in exchange for full cooperation and restitution of $94,000, representing his board administrative fees over the relevant period. His cooperation had included producing internal HOA communications that the prosecution had used to establish the knowing concealment element of Count 3 against Brandon. Brandon's sentencing was March 3rd. The judge, the same judge who'd presided over the trial, the Honorable Carlos Reyes of Sierra County District Court, reviewed the scope of the scheme, the duration, the 180 households whose trust had been violated, and the sustained concealment over 14 years. 5 years. Eligibility for parole after 3. The civil judgment had been entered in January, after the criminal conviction made the summary judgment motion effectively unrebuttal. Judge Sandoval had reviewed the damages evidence and entered the full amount on all 4 counts. Pipeline trespass, $340,000. Unlicensed use restitution, $162,000. Misappropriation damages, $847,000. Punitive damages, $1,694,000. Attorney fees and costs, $94,200. Total judgment, $3,137,200. Judge Sandoval had written 4 paragraphs on the punitive damages finding. Sandra read me the final one over the phone on the morning the judgment was entered. The defendant collected money from 180 families for 16 years under the representation that it funded the water supply infrastructure their homes depended on. A fraction of that money went to infrastructure. The majority went to the defendant's own company through an arrangement he created, maintained, and concealed over 14 years. The defendant compounded this misconduct by refusing to negotiate a legitimate water supply agreement with the owner of the water source for 5 months, a refusal that ultimately left 180 households without water for 72 hours. This court finds that the pattern of conduct, sustained, deliberate, and specifically designed to extract maximum personal benefit from a fiduciary position, warrants punitive damages at the full amount requested. I sat with that for a moment. She gave the full amount, I said. Every dollar. Brandon's assets, his commercial brokerage, his personal real estate holdings, including a house in Truth or Consequences, and a rental property in Albuquerque, his business accounts and investment accounts were subject to collection proceedings. The brokerage had been assessed at $420,000. The properties, combined, at $680,000. His liquid accounts at approximately $290,000. Total collectible assets, approximately $1,390,000, against a judgment of $3,137,200. The remaining $1,747,200 would follow him. Vell Property Services LLC was dissolved by court order on February 20th, 9 days after the conviction. The dissolution order directed that all remaining assets of the company, including accounts receivable and any pending invoices, be transferred to a court-administered restitution fund for distribution to Crestfall Ridge Community Association members. The restitution fund contained $47,000, against $847,000 in misappropriated funds. The gap, $800,000, was part of the civil judgment collection proceedings. It would take years. Some of it would never be recovered. But it was documented, it was ordered, and it would follow Brandon Vell for the rest of his working life. The permanent agreements took 3 months to negotiate and finalize. The reformed HOA board, Rita Salas had been elected president at a community vote in November, in which Brandon's name had not appeared on any ballot because he was awaiting criminal trial, had approached the negotiation with the straightforward practicality of people who understood that they needed what Walter had, and that the time for games was over. Their independent counsel and Sandra had worked out the framework in the first week of November. 2 agreements, recorded separately, documented completely. The first, a permanent pipeline easement for the 1.4-mile corridor across Briggs Canyon Ranch. A 25-year term with renewal rights. Annual easement fee at current Sierra County fair market rate, $23,500 per year. The same figure Sandra had used to calculate the trespass damages, now formalized as the ongoing compensation. Escalation formula tied to the Sierra County Property Index, capped at 3% per year, title insured, recorded in Sierra County. The second, a water supply agreement covering the Clear Spring Aquifer Station number 4 parcel's pump operation, and the water rights certificate, a 25-year term. Monthly operational fee covering Walter's costs of maintaining the parcel, plus a reasonable return on the $47,000 acquisition cost. The HOA retained the right to maintain the pipeline and the pump equipment under a maintenance access agreement that was part of the same document. Title insured, recorded in Sierra County. Both agreements contain the same provision on page 1, the same plain language disclosure I'd insisted on, explaining in clear terms the ownership structure. Walter Briggs owned the pump station parcel and the water rights. The HOA held a permanent recorded easement for the pipeline corridor and a long-term water supply agreement. Neither document gave the HOA any ownership interest in either parcel. No HOA president would ever again be able to tell their community that the water situation was fully secured, without being able to point to a recorded document proving it. The agreements were signed December 15, 2025, recorded in Sierra County December 17, title insured December 19. The Crestfall Ridge Pipeline was, for the first time since January 1, 2011, operating legally on Briggs Canyon Ranch. 17 years. 15 of trespass, 2 of proper authorization before the temporary easement ran its course. Now, finally, a permanent recorded instrument that said what was true and bound both parties to terms they'd negotiated with full knowledge of the facts. My grandson visited in January. Tyler was 16, visited every summer and usually at least once in winter when his school schedule allowed. He had his mother's eyes and my tendency toward long silences and open country. The kind of quiet that isn't uncomfortable because there's too much to look at to fill it with words. We rode the fence line on a Thursday morning. January in the high desert, cold and clear. The kind of cold that makes the air feel like something you can hold rather than breathe. The canyon ridgeline sharp against a sky that had no clouds and no apology for being exactly what it was. We reached the north pasture at mid-morning. Tyler pulled up his horse at the creek crossing and looked at the pipeline bridge section. The 40-foot steel span over Briggs Creek, the same structure Brandon Vell had been photographing 10 months earlier. He looked at it for a while. "Grandpa," he turned in the saddle, "when that guy told you not to step on the pipe, what did you think?" I looked at the pipeline running through my pasture. I thought about the right answer, not the complete answer. Some things take longer than a morning's fence ride to say properly, but the true one, the one that had been forming since March, since the creek crossing, since the moment I'd read Section 7, Paragraph 3 of the 2008 easement and handed the document back to a man who'd never read it carefully enough to know what he was holding. "I thought about your great-grandfather," I said, "building this ranch in 1931, coming out here with $800 and a team of horses, and the particular kind of stubbornness that decides on a place and doesn't move. About what it takes to hold land in the desert for 3 generations, not just the money and the work, but the attention. Knowing what you own, knowing who's on it, knowing when something's wrong." I looked at the pipeline. About how many people over the years have looked at this ranch, looked at an old rancher checking fence line, and thought, that old man won't fight back, he'll just let it go. Tyler was quiet for a moment, watching the creek move under the pipeline bridge. Were they right? I looked at the pipeline running clean and straight through my north pasture, operating under a recorded easement, on a corridor owned by the Briggs family since my grandfather had first staked the posts, drawing from a water source that now had my name on the deed. "Brandon Vell found out," I said. We rode the rest of the fence line without speaking. The high desert does what it does in January, cold and specific and indifferent to anything except what's actually there. The canyon wall, the sage, the creek, the sky. The ranch my grandfather had built and my father had expanded, and I had held and would pass to my children and to Tyler after them. The pipeline ran through the north pasture exactly as it had run for 17 years. The difference now was the document in the Sierra County Recorder's office that said it belonged there. That was, in the end, the only difference that mattered. Brandon Vell had walked onto Walter Briggs's ranch without permission and told a retired water engineer to stay off his own pipeline. 6 months later, he had a criminal indictment on 3 counts, a civil judgment of $3,137,200, a dissolved company, and a water source he'd never controlled being operated under a signed agreement by the man he'd tried to dismiss at the creek crossing. Walter Briggs had been a hydrological engineer for 30 years. He had designed water distribution systems for southern New Mexico, testified as an expert witness in 14 water rights cases, and spent a career understanding exactly where every drop came from, where it went, and who owned the ground it traveled through. He had been looking at the Clear Spring Aquifer Station No. 4 parcel for 3 years. He had been waiting for the right reason. Brandon Vell gave it to him on a Tuesday morning in March. Brandon Vell found out what happens when you tell that man to stay off his own land.